afternoon. For August 26, 2026, the Senate President Sherwin Gatchalian opened the session at exactly 10 a.m. with 17 senators present, constituting a quorum for the 19th day of the impeachment trial. For administrative matters, the presiding officer confirmed receipt of the motion to set a conference for marking of additional exhibits from the Philippine Statistics Authority, which was received on Tuesday, August 25, 2026 at 5:20 p.m. and granted the same to allow it this afternoon at 4 p.m., instructing both parties to be there. The presiding officer confirmed receipt of the letter from Lieutenant Colonel Manaros Boransing II to be excused from attendance today because he needed to ask permission to leave his post, and granted the same and issued a subpoena for him on September 1, 2026. The presiding officer also granted the motion of the House Prosecution Panel's lead prosecutor, Congressman Jervil Luistro, to drop retired Major General Adonis Bajao. The presiding officer also granted the issuance of subpoena ad testificandum to Ms. Marisa V. Grande of the PSA for September 2 to 2026. As to the request for subpoena for Attorney Michael Powa, the presiding officer merely informed him in open court. The presiding officer also granted the motion of the House Prosecution Panel supplemental request for subpoena duces tecum for bank records and to be submitted on September 2, 2026. The presiding officer confirmed that pertaining to the statement posted by the respondent, the ruling prospectively applies, but instructed sternly the respondent's counsel to remind the respondent of the application of his ruling even to her. Upon inquiry of Senator Judge Ping Lacson, the presiding officer confirmed that the impeachment court has the power and discretion to call on witnesses or recall witnesses to satisfy its search for truth, citing People v. Valera and City of Cebu v. Gaco Jr. Before the start of the presentation of evidence, the respondent's counsel, Attorney Michael Powa, manifested to the court that counsel for prosecutors, Attorney Maydi Vinegracia, had repeated the impertinent words in an interview right before the hearing. The presiding officer noted, or right after the hearing, the presiding officer noted that the said manifestation and confirmed it will be addressed in his ruling. After hearing Attorney Ligutan's response, the presiding officer rendered his definitive ruling, which establishes strict guidelines to preserve the constitutional integrity of the trial, ensure due process, and halt extrajudicial trial by publicity. The triple ruling on court decorum and duty to comply with Rule 18. I will summarize the ruling. As to the senator judges and internal ethics remedies, before imposing rules on the trial counsels, the impeachment court first put its own house in order. The presiding officer reminded the senator judges of their solemn oath to maintain cold neutrality. However, applying People v. Guambor, the court clarified that neutrality does not mean passivity. Senator judges retain the absolute right to propound searching cross-examination style questions to extract the truth. Piercing questions that destroy one's theory of the case do not constitute bias. Furthermore, firmly establishing the Senate's institutional independence via Pobre v. Defensor Santiago, the presiding officer ruled that any allegations of ethical breaches or bias by senator judges shall be handled strictly via internal remedies through the Senate Committee on Ethics and Privileges, not through the media. Furthermore, the presiding officer laid down strict rules on in-court decorum for the tribunal itself, invoking Senate Rules Section 93 to 96. The court strictly prohibited senator judges from engaging in unparliamentary remarks, personal attacks, and imputations of improper motives during the proceedings. While extending courtesy and latitude required for vigorous debate, the presiding officer issued a firm reminder that language incompatible with the dignity of the chamber will be met with strict enforcement of parliamentary rules. As to the parties and counsels, Addressing the sub-judice rule under Rule 18, the presiding officer extended institutional grace, declaring tabula rasa or clean slate for all past public statements, including the statement of the respondent just this afternoon. Moving forward, a zero-tolerance policy applies. No party, counsel, or witness may publicly comment on the merits of the case, which includes predicting outcomes, assessing evidence, or evaluating witness credibility. The court issued an ultimatum to the legal panel's lead counsels, specifically noting Attorney Tolosa and POA being spokespersons and counsels at the same time, that they must either cease acting as media spokespersons or officially withdraw as counsels of record. The presiding officer reiterated that counsels must litigate their respective causes before the impeachment court, not in the court of public opinion, through interviews, social media posts, or publicly generated, authorized, encouraged, or conducted through surrogates. The official guidelines as to scope of coverage, it applies to the presiding officer, senator judges, House prosecution panel, the counsels for the House prosecution panel, the respondent, Vice President Sara, the respondent's counsels, and all witnesses. For those not covered by Rule 18 and the Code of Professional Responsibility and Accountability, or CPRA, they shall be covered by the suppletory application of Rule 71 of the Rules of Court on indirect contempt in relation to the standards laid out by the Supreme Court in ABS-CBN versus Ampatuan. As to the substantive guidelines on what constitutes prohibited comments on the merits, relying on the Supreme Court jurisprudence, the Impeachment Court defines commenting on the merits to include, but is not limited to, A, assessment of evidence and witness. Pursuant to the en banc doctrine in Badoy versus Magdoza Malagar, to speak on the merits comprehensively means making public statements that evaluate a disputed fact or substantive issue before a formal verdict is reached. It is strictly prohibited for any covered party to publicly discuss, attack, or defend the credibility, truthfulness, or motive of the witnesses. Number 2, to assess the character of the accused or the respondent. Number 3, evaluate the soundness of the alibis, complaints, or defenses offered. Number 4, evaluate the admissibility, relevance, weight, or sufficiency of the evidence presented. And number 5, generally, any other comment, hearing on the guilt or innocence of the accused or the respondent. And what is allowed? The fair and true report exception. Conversely, the presiding officer recognized the qualified privilege of a fair and true report regarding the proceedings as affirmed by the Supreme Court en banc in ABS-CBN versus Ampatuan, based on the jurisprudential standard derived from Article 354 of the Revised Penal Code. A fair and true report means a neutral and objective and accurate recounting of the proceedings made in good faith, without any comments or remarks. Letter B, prejudging the outcome and pressuring the court. Pursuant to the en banc case of INRE, published threats hurled by Attorney De Vera, no covered person shall make public statements, insinuations, or rhetorical questions that, number 1, prejudge the issue to predict the outcome of the trial. Number 2, question pending rulings. Number 3, substitute media pressure for evidence. Number 4, promote distrust and undermine public confidence in the impeachment court by creating the impression that the impeachment court cannot be trusted to resolve cases impartially and violate the right of the parties to have their case tried fairly by an independent tribunal uninfluenced by public clamor and other extraneous influences. Letter C, the CPRA standard for lawyers. Pursuant to Canon 2, Section 19 of the CPRA, all counsels are prohibited to comment or publicize opinion pertaining to a pending proceeding in a manner that may cause prejudgment, sway public perception, influence the tribunal, or create a widespread perception of guilt or innocence. CPRA likewise requires professional responsibility in the use of social media and prohibits the dissemination of false or unverified claims or disinformation. As to the summary due process and the two-strike rule, citing Zaldivar versus Sandiganbayan, the Impeachment Court will issue a mere 24-hour show cause order for suspected violators to submit a written explanation explicitly dispensing with lengthy trial-type hearings. Crucially, under Stradcom versus Etong and Webb versus Gatdula, any punitive sanction requires the Impeachment Court to find that the person's act must be done willfully or for an illegitimate or improper purpose. Thus, the good faith or lack thereof of the person being cited in contempt should be considered. Therefore, the accused is presumed innocent, and the burden to prove willful bad faith rests heavily on the complainant or the movant. Violators may face a strict two-strike rule. Strike 1, severe public reprimand and stern admonition on the record. Strike 2, maximum 30,000 statutory fine and a case management floor restriction wherein the offending lawyer or party will be subjected to a defined prospective restriction on speaking, objecting, or examining witnesses on the floor. For members of the bar, based on the case of in regard to Attorney Almacen, the certified incident record will be transmitted and a formal referral will be made to the Office of the Bar Confidant, the Integrated Bar of the Philippines, and or the Supreme Court for disciplinary sanction regarding the person's license to practice. Number 4, in-court decorum, direct contempt, and stricken words. While Rule 18 governs outside media statements, the presiding officer set equally rigid boundaries for legitimate advocacy inside the courtroom, citing Navarrete versus Court of Appeals and Baltao versus Falsis III. The court warned that zealous advocacy is never a license for offensive, abusive, or intemperate language. Asserting strict courtroom control, the presiding officer ordered stricken of the record the inflammatory terms scam, mastermind, and modus operandi, previously used during the proceedings. Counsels are directed to advance their theories through reasoned arguments and evidence, not derogatory characterizations. The court issued a stern warning: disrespectful or offensive language uttered inside the chamber that obstructs the proceedings will be dealt with immediately as direct contempt under Rule 71, Section 1 of the Rules of Court, alongside separate disciplinary referrals for violations of CIPRA under Canon 2. And citing Attorney Francisco versus Attorney Zuniga Lagman for the prosecution and People versus XXX for the defense, both panels were reminded by the presiding officer that their paramount duty is the rigorous pursuit of justice and the protection of constitutional rights, not victory or acquittal at all costs. For the presentation of evidence in chief for Article 1, the continuation of the testimony of Mr. Lemuel G. Ortonio, the counsel for the House Prosecution Panel's Attorney Midi Vinagracia conducted the direct examination, and afterwards, the cross-examination was conducted by Attorney Christine Ferrer, while redirect and cross-examination were conducted by the same counsels. 12 senators rigorously interpolated the witness and counsels under 3 themes. Theme number 1, as to the blind signatory defense and the reliction of verification, Senator Judge Rafi Tulfo questioned why a highly educated official was satisfied with bare claims, failed his duty to ask questions before signing the AOM replies, and whether he even bothered to ask the concerned persons about the AOM findings. Senator Judge Kiko Pangilinan pressed the witness on why he did not go through all the acknowledgement receipts when drafting the AOM reply, asking point blank if anything physically stopped him from opening the evidence envelopes to do his job. Senator Judge Erwin Tulfo challenged the witness's competence, asking why he answered the AOM when he admittedly knew nothing about intelligence activities. If the drafted reply relied solely on Colonel Lachica's claims, and if he harbored any doubts regarding the implementation. Senate President Sherwin Gatchalian probed the witness's blind trust, asking what actions he took to verify the ARs, why he fully trusted Colonel Lachica without probing further before signing the AOM reply, and questioned the OVP's reply regarding who paid 3 months in advance. Senator Judge Joel Villanueva asked about the witness's extent of authority in signing for the Vice President and why he blindly provided his signature without demanding details about the disbursement arrangements. Theme number 2, procurement absurdities and the sickly informants, quote, and fictitious aliases. Senator Judge Raffy Tulfo highlighted the absurdity of the justification, asking for details on the medicines purchased, sarcastically inquiring if the informants are usually sick, and why the massive allocations didn't make the witness curious about their health. He also asked why the witness didn't ask for the actual names behind the ARs. Senator Judge Erwin Tulfo established the civilian nature of the OVP, which does not conduct surveillance supposedly. He explicitly questioned the purchase of furniture using confidential funds, asking if the witness knew this is a direct violation of the COA-DBM Joint Circular. He also asked where the aliases came from. Senator Judge Bam Aquino focused on the institutional reaction to the anomalies. He asked about the OVPs and the respondents' reaction to the absurd aliases, whether anyone raised concerns, and if an internal investigation was ever launched after receiving the AOM. Senator Judge Ping Lacson scrutinized the foundational paperwork, asking if the witness is the designated financial officer, noting the physical and financial plans or PFP contained identical copy-pasted entries, and questioned if the underlying intelligence information had already been formally declassified. Senator Judge Robin Padilla, offering a counter perspective on covert operations, defended the use of aliases by noting that historical heroes, specifically Noy Aquino using Marshal Bonifacio, legitimately utilized them for law and order purposes. As to theme number 3, upward tracing of accountability, proxies, and chain of command, Senator Judge Risa Ontiveros targeted command responsibility directly. She asked if the respondent knew of approved and had the last touch on all the replies sent to the COA. She asked about the chain of trust regarding the encashment and pressed him to confirm that the respondent is ultimately the accountable officer for the funds. Senate President Sherwin Gatchalian asked if Colonel La Chica ever confirmed receiving the 500 million, how the witness thought La Chica would implement the projects, and demanded to know who in the OVP only actually knows how the confidential funds were spent. Senator Judge Erwin Tulfo questioned the proxy's legal authority, asking if Colonel La Chica was a legally bonded official and why he was authorized to hold such massive amounts of public money. Senator Judge Tito Soto questioned the organizational structure, asking what exact official item or plantilla position Colonel La Chica held within the OVP to justify his control of the funds. While Presiding Officer Chis Escudero exposed a critical accounting inconsistency. He probed whether Colonel La Chica was legally authorized to handle the money and questioned the defense's shifting theory, asking whether La Chica claimed to be the actual end user who submitted his own AR or merely a conduit who later replaced his AR with receipts from fictitious informants. Following rulings by the presiding officer Escudero on various evidentiary motions and objections by both parties, the trial was adjourned. Pursuant to the rules of procedure on impeachment trials, the Impeachment Court will resume session on Tuesday, September 1, 2026 at 10 a.m. The agenda is a continuation of the representation of the House Prosecution Panel's case-in-chief for Article 1 through the start of the presentation of their 8th witness, Lieutenant Colonel Manaros Boransing II, AFP representative. Any questions? Yes po.
Sir, parang nabanggit din yata ni presiding kanina about La Chica na pwedeng ipatawag siya ng court kung hindi pa patawag ng both sides. Sir, yun ba kung ipatatawag siya, si presiding officer lang po ang magdidesisyon o kailangan pagbotohan kung papayag lahat ng senator judges? Paano po?
Nakalagay po sa ating Senate Rules on Impeachment na kapag mga ganyang evidentiary na mga rulings, the presiding officer can rule by himself or upon his own discretion, submit the question for the decision of the senator judges as a whole, as a collegial body. So kapag nag-rule na siya dyan at wala naman nag-apela, then yun na yung ruling ng korte. Pero on the first instance, pwede nga rin naman ibato yung tanong na yun sa ating mga senator judges para pagbotohan. Pero initially, ang preferred ni presiding officer, he makes the ruling himself.
Sir, pwede rin mag-request ang isang senator judge na presiding officer, paki-invite, paki-subpoena itong si Colonel La Chica. Pwede po yun.
Tama po kayo. Bilang a collegial body, the presiding officer is just one among equals, no? He is just presiding, pero equal po sila. So any of the senator judges can also request that the court issue a subpoena ad testificandum to Colonel La Chica at the end of the presentation of the prosecution's evidence in chief and at the end of the presentation of the defense's evidence in chief. So kahit na ipatawag po, kunwari ang isang testigo ng any of the parties, pwede pa rin within the power ng ating impeachment court na i-recall din yung witness na yon. Kung wala naman at hindi ipinatawag yung mga witnesses na yon on the first instance, pwedeng magpatawag din ng additional witnesses ang ating korte because ultimately the impeachment court wants to get into the truth of the matter.
Sir, napasadaanan naman kanina, no? But as a clarification, yung sub-judice ruling covers everybody inside the courtroom, no? Senators and even the respondents. Can you just elaborate on the coverage of Vice President Duterte and the process? Kung halimbawa, paano yun? Kung may violation allegedly, paano po yun, sir?
Katulad kanina, no, may nag-raise ng possible violation ng respondent, no, si House Lead Prosecutor Jervil Luistro. However, it was determined by the presiding officer that the posting of the said statement by the respondent was made at around 10:19 in the morning, which is at the same time that the presiding officer is just started his ruling on the matter. So dahil hindi pa po siya natatapos basahin yung ruling na yon, hindi nga pa sinasabi yung so order that hindi nga pa binabang yung gavel. So wala pa pong ruling at the time na 10:19. So nung pinost po yun, kasama na po siya doon sa prospective application. Meaning, wala pa siyang nilalabag at the time ng 10:19 ng umaga na yon dahil hindi pa tapos yung ruling sabihin ng ating presiding officer.
But moving forward, if there are allegations of violation by the respondents, paano po yung pag-raise doon?
Yes. That's why yung lahat kasi nabigyan na ng first warning, no? Even the spokespersons and the ating mga counsels, no? Now, the respondent, binigyan na rin kanina ng first warning ng ating presiding officer through the respondent's counsel, yung respondent, na pagsabihan siya na siya ngayon ay covered nung Rule 18 ng ating Senate impeachment rules. At kung merong mag-raise ng violation after today, by any party or any person, ang first penalty, syempre bibigyan mo ng 24 hours to reply para magkaroon ng due process kung bakit mo sinabi to, bakit ganito yung ginawa mo, meron bang basehan yung complaint sa'yo. After the 24-hour submission ng written explanation, the presiding officer will summarily just issue a ruling kung may finding of violation o wala. Kung may finding of violation, i-impose nga yung first strike, which is admonition, reprimand in open court. Now, kapag hindi pa rin tumino yung isang tao at continues violating the sub-judice rule or the court imposed a proper decorum and language in the courtroom, then sa strike 2, after again 24-hour ruling, 24-hour written explanation receipt, kapag ito ang second offense na, i-impose na yung 30,000 penalty na fine on the person for every violation. And then kapag talagang third strike, fourth strike na, hindi na talaga natuto even without even with fine, then the presiding officer will issue an order to refer the matter to the Supreme Court for the disciplinary action by the Supreme Court of the person kapag siya ay covered by the CIPRA nung aming ethical duties as a lawyer.
Sir, rule of thumb lang for the public, just so they process the concept, no? Yung sub-judice, Paano ba yan? So dapat hindi nililitis sa labas ng court? Can you just give us a rule of
Tama
thumb?
po. So, meron tayo sa dalawang rule ang nag-a-apply sa aming mga abogado po, lalo pa yung mga covered persons. Kaya sinasabi ni presiding officer, kung spokesperson ka, wag ka na lang maging counsel of record. Kasi kapag spokesperson ka lang, hindi ka covered under Rule 18. Covered ka lang ng Canon 2 Section 19 ng SIPRA, if ever. So, pero kapag ikaw ay counsel of record, covered ka rin ng Rule 18 ng Senate Impeachment Rules. So, ang sub-judice under Canon 2 Section 19 ng SIPRA namin, bawal kasi in any forum na mag-litigate ka. Sabihin yung mga merito ng kaso to cause a prejudgment, to sway public perception, para ma-obstruct or ma-impede or to influence the decision of the court or the tribunal, to impute improper motives to any of the members of the tribunal and the tribunal itself, and to create a widespread perception of guilt or innocence before a final decision. Ang ibig sabihin, kung abogado ka, litisin mo yung kaso mo sa loob ng korte, huwag sa labas ng korte. Hayaan mo yung ibang tao na hindi counsel of record ang maglitis nun sa labas ng korte. Pag ikaw ay counsel of record, you do it by evidence through the court proceedings natin.
All right, sir. Thank you.
Attorney, on the part naman po of the counsel, so does that mean na wala na po tayo makikitang post nila online na carrying words or phrases that may have to do with the impeachment proceedings po? Bawal na po ba talaga yun? Kumbaga, ano yung magiging
Alam naman po
distinction?
natin, kahit meron tayong pagbawal, ang dami po nating mga batas, 'di ba? Kung gustong labagin, lalabagin po. Pero at least ngayon po, ang maganda po nangyari dito, malinaw na po. Hindi na po tayo manghuhula. Ano ba ang sub-judice? Ano ba yung comments on the merits? Nagbigay na ng example kanina ang ating presiding officer. So anything na nagdi-discuss ng merito ng kaso, ng ebidensya, sinasabi mo na yung pinatunayan ng testigo na to, ganito to. At ganito ang ibig sabihin nito. Ina-analyze mo, nagkakaroon ka ng conclusion of fact, nagkakaroon ka ng conclusion of law. But that was not allowed in open court during the trial. Bawal po yung ganon, no? Pero ikaw, ginagawa mo siya sa labas ng korte. So yun po yung pinagbabawalan kasi you're both trying the case inside the court and then outside of the court as well, which is wrong because you are courting publicity for yourself and for the evidence na trying to influence the judges to go the way that you want them to go.
Attorney, so technically po ba masasabing lumabag dito sa rule yung pinost ni Attorney Ligutan?
I think walang finding na ganon because of the fact that the presiding officer didn't want to make a determination of any violation. While he said, no, kanina may mga examples siyang ibinigay na mga sinabi in the past ng ating mga counsels at parties, hindi niya ito ibig sabihin determination of any violation. Maingat siya dun sa wording na yon. There was no determination of a violation. Sinasabi niya lang, ito ang mga example. Pero dahil nga doon sa institutional grace na ibinibigay ng ating impeachment court, and by being liberal about it, katulad nung sinabi niya mula nung umpisa, hindi niya muna paparusahan yung mga parties. Hinayaan niya muna ng konting breathing room. Kaya tabula rasa na or clean slate na. Hindi niya na pininalize yung mga previously na may mga nagsabi. So as to Attorney Ligutan, wala talaga siyang determination na bawal yun or hindi.
Kumbaga may warning na po sa lahat.
Warning lang sa lahat.
Attorneys, last na lang po on my part. Pagdating naman po kaya sa senator judges, while nagpaalala na po si presiding officer, baka lang po maging question again ng mga taong nagbabantay o nanonood ng impeachment. May mga senator judge din po may binibitiwang mga comments or remarks habang nagbabato po sila ng clarificatory questions. May tanga-tangahan, pero pina-reward na po yan ni presiding officer. Yang mga yan po ba may hangganan na pagdating dito sa rule na to?
Tama po kayo. Kasama po sa ruling ng ating presiding officer kanina, yung sinasabi niyang unparliamentary language na mag-a-apply yung rules nila sa Senado on unparliamentary behavior and language. Na kapag may any senator judge na lumabag nun, that senator judge can be subjected to ethics committee na sanction. Pero kailangan may mag-raise doon na party or a fellow senator judge.
So pwede pong kung sakali magkaroon ng complaint or paano po ba yun? Dapat manifestation o pwedeng complaint na
Complaint po. So, the councils, kapag sila ay nakapag-encounter ng ganong mga intemperate language from a senator judge that may be considered as unparliamentary language or actions, then the councils themselves can raise it on the floor for the presiding officers. Possible, kung nag-agree yung presiding officer, mag-order siya to refer it to the ethics committee ng Senate. Kapag hindi siya nag-a-agree, then papatayin niya na yung issue on the floor, right then and there.
Pero hanggat wala naman pong, kunwari lang po, formal complaint or manifestation regarding this, only the senators themselves can police each other po.
Correct.
Additional question po doon, attorney. Is it only the councils from both parties yung pwedeng mag-raise or can the general public also raise the concern? Lalo na ethics committee naman yung magta-try sa kanila.
Tama ka po, no? Dahil ito po ay papasok na doon sa rules ng ating Senate, no? As a legislative body, any person can already raise as well the violation of ethical duties by the senators under the Senate rules. Kaya sinait kanina ni presiding officer yung Rule 34, Section 93 hanggang Section 96 ng Senate Rules. Para pati yung mga publiko, kung may makita silang impropriety from the actions or the language of any senator judge, then they can do so.
For moving forward po, attorney, will the Senate as an impeachment court be, kasi nabanggit niyo po before, passive lang pagdating dito sa mga possible violations for sub-judice. Moving forward, since may ganitong ruling na po, actively ba ititignan na din nila yung mga posts ng magkabilang council or dapat pa rin i-raise yun ng councils from either teams?
The preference of the impeachment court is that it sits as a passive body, that those kinds of issues should be raised by both parties. So, yun yung unang preference ng ating impeachment court. So, it also goes to show kung gaano kapasensyoso ng ating impeachment court regarding those kinds of matters. That's why wala kayong narinig sa impeachment court about these things despite and in spite of the fact na marami ng mga alleged violations na napapansin ng impeachment court. Hindi siya gumalaw until attorney season manifested last time. And that triggered the ruling of the presiding officer on the matter. Wala na po. Thank you. Maraming salamat po. Good afternoon. Sino po?
Hindi naman masama gumamit ng alias, di ba?
May alias